So really, as I said, these are two different provisions of the New York labor law, and we're going to talk about them in turn. The first one is a set of requirements related to airborne infectious disease exposure prevention. Now, this is easily confused at this point with a COVID-19 specific piece of legislation. I think it's fair to say that under the law, COVID-19 would qualify as an airborne infectious disease, but the law doesn't say anything about COVID-19 or even coronavirus generally. It more broadly includes any possible airborne infectious diseases, which pretty much means any disease that has a significant potential impact on public health that can be transmitted through the air, as the name suggests. So every employer will need to adopt an airborne infectious disease exposure prevention plan. It's a real mouthful to do this, and there's not an obviously convenient abbreviation because of the way that the words are spelled out. And whether you want to call this an AIDS prevention plan is sort of questionable, noting that HIV and AIDS itself would not be an airborne infectious disease, for example. But anyway, what is going to happen is the New York State Department of Labor must create industry-specific minimum standards and model plans. And based on the timing of the law itself and the anticipated amendments, it seems likely that the Department of Labor will have those standards and model plans out sometime this summer.